Okay, welcome to the course unit 4, History, Forerunners, Philosophy, and Concepts of Probation. Yung ating subject na correction, non-institutional correction, malaking part nun is ang ating probation. Most of the topics are all about probation. Siguro mga 3 modules is related sa ating course, sa ating probation. So, this is the history, forerunners, philosophy, and concepts of probation. So, what is probation? Again, as we all know, probation, okay, was termed and coined by John Augustus. Again, probation was coined and termed by John Augustus from the Latin verb probare, which means to prove or to test. So, probation, again, is a disposition whereby a defendant, after... Ronnie, please close your mic. Oh.
Sorry, ma'am.
Okay. Probation is the disposition whereby a defendant, after a conviction of an offense, the penalty which does not exceed 6 years of imprisonment, it is subject to the conditions imposed by the releasing court and under the supervisions of officers. Okay po. Ganito kasi, hindi naman lahat may karapatan, di ba? Sabihin nga natin, probation, it is just a mere privilege. Oh. Hindi naman lahat is, tawag dito, may karapatang mag-apply sa probation. Ang na-apply lang dito, the penalty which does not exceed 6 years of imprisonment. So, for example, si Kino Corpus is convicted of a crime murder, tapos meron siyang penalty na 12 years, ganyan. Therefore, hindi siya pwedeng mag-apply. Sa probation kasi, kailangan, okay, ang specific penalty mo will not exceed 6 years. So, kung ang penalty mo is, for example, 5 years lang, 2 years lang, therefore, ayan, pwede kang mag-apply sa probation. Intindihan? So, by probation, a person is convicted of a criminal offense and it is not to send to prison. So, by sentencing court. So, instead, he or she released, placed under the supervision of a probation officer subject to conditions which the court may impose. Ang kinaganda sa probation, okay, once na you undergo this, okay, ang mangyayari dyan, hindi ka na po talaga totally na magsaserve pa sa loob ng kulungan. Automatically, after your conviction and you applied for probation, okay, and then na-approve siya or na-grant siya ni court, therefore, okay, hindi ka na pupunta sa kulungan. Ang gagawin dyan is magkakaroon ka na ng community, tawag dito, community service within the supervision of a probation officer. Sabi nga niya, subject to the conditions. So, ibig sabihin, hindi ibig sabihin nang nasa labas ka, wala ka nang gagawin. So, kahit nasa labas ka dahil you undergo with the probation, therefore, you will set your life with the conditions. So, probation is a substitute for imprisonment. So, the probationer is compared to an outpatient, a sick person who does not need to be hospitalized because his illness is considered less serious. So, kung ituturing nga natin ang probation, sabi nga niya, it is a substitute for imprisonment. Therefore, ang nangyayari dito, sabi nga niya, para kang may sakit. Di ba, for example, yung iba, parang may sakit lang na hindi naman kailangan i-hospital. So, parang simpleng lagnat lang or ubo na kailangan, pwede naman siyang pagalingin sa bahay lang. So, kung kanwari sa mga probation, sa mga probationer, okay, yung mga nag-a-apply sa probation, yung mga taong to, it means yung kaso nila, hindi naman ganun ka-serious. Okay po? Kaya nga sabi niya, less serious. Diba? For example, kaya nga sabi ko, diba, katulad ng sinabi niya kanina, it does not exceed in 6 years of imprisonment. So, kung kanwari kanina si Queen Corpus na pumatay naman, ang kaso niya is sabihin natin merong 12-year penalty, therefore, hindi siya pwedeng mag-apply sa probation. Kasi nga, again, yung mga pwedeng lang mag-apply sa probation are those with a penalty of 6 years below yung kanilang parusa. So, is a probation a right? Again, generally, probation, it is not a right, okay? No, it is a mere privilege for adult offenders. However, okay, po, if the convicted is a juvenile or youth offender under RA 9344 or Juvenile Justice and Welfare Act of 2006, a child in conflict with the law, yung ating CICL, it is granted the right to probation as an alternative to imprisonment if qualified under the probation law. Again, kapag, di ba na-discuss na nito last week, kapag ang offender is already, it is a youth, or ang age niya is 18 years below, for example, 16 years old siya, tapos nagkaroon ng trial, tapos na-convict siya as, or nagkaroon ng parang gantong sentence na murder talaga ang crime niya. Therefore, hindi siya ikukulong right away. Anong gagawin niya? Sige nga, if you could remember, anong gagawin
Rehabilitation
sa kanya?
center, ma'am.
Dadalhin siya sa rehabilitation center ng alin? Ng
Yes,
DSWD. Okay, yung tawag dun sa parang waiving na yon, okay, it is a probation. It is a probation. Karapatan niya ng bata kasi nga wala pa siya dun sa legal age. So, purpose of probation, why we are having a probation? Number 1, to promote the correction and rehabilitation of an offender by providing him with individualized treatment. And number 2, to provide an opportunity for the reformation of a penitent offender. And penitent means feeling or expressing humble or regretful for offenses. So, prevent of commission of offense. So, yan yung mga purposes ng probation. Sabi nga niya, we can promote the correction by giving individualized treatment. Ibig sabihin, kapag nag-undergo ka ng probation, dapat yung mga set of conditions mo, hindi naman kamukha nung nasa iba. Also, they provide an opportunity for the reformation of a penitent offender. Pag sinabi kasi nating penitent offender, ibig sabihin, talagang lubos na nagsisisi, diba? Ibig sabihin talagang tinatanggap niya yung pagkakamali niya. Sabi niya, feeling or expressing humble or regretful for offenses. So, what are the benefits for probation? Number 1, it protects the society from excessive cost of detention. Bakit? Siyempre, di ba, kapag nag-undergo sila ng gantong community correction, ibig sabihin, nababawasan yung pinapakain ng gobyerno sa loob ng preso. From high rate of recidivism or for committing the crimes again, protects the victim from, or it provides a restitution, di ba? Returning something, payment for damages. Ayan, binabayad na lang or in exchange, may kapalit na lang. It serves justice. Again, another naman, it protects the family. It does not deprive a family member. Kasi kahit na may kasalanan siya, na-convict siya, okay, kung mag-undergo naman siya ng probation, therefore, hindi niya kailangan mawalay sa kanilang mga pamilya. And it maintains the unity of homes. So, ano pa? Assist the government saan? Ito, sa number 1 problem natin sa mga jails and prison, yung ating overcrowding. So, therefore, mare-reduce yun. It lessen the clogging of courts. Clogging of courts, diba, yung napakadaming nilang mga cases na hindi naman natapos-tapos. Enlighten the loads of prosecutor. And it helps the offender by what? Maintaining his earning power. Kasi, pwede rin ito, kung kunwari, penitent offender naman siya. Okay? Kung kunwari, penitent offender naman siya, di mas maganda na ibigay na lang natin yung ating, parang mag-apply na lang siya sa probation. Bakit? Kasi po, di ba, kung nagsisisi naman yung tao or parang hindi naman ganun kalala yung kasalanan niya. Therefore, di ba, mas okay na lang na ibigay natin yung probation kung controllable naman siyang nasa labas. Sabi ko nga, ang probation, it is just a mere privilege. Kaya hindi naman lahat ay inaalaw na magkaroon ng privilege. So, nag-undergo pa yan ng parang qualifications. So, another benefit, it helps the offender. Di ba, kapag alam nating ex-convict kasi ang isang tao, for example, okay, nakulong ka, tapos kabalik mo dito, kapag nag-integrate ka na within the community, di ba nawawala yung power mo? Parang nawawala yung confidence mo sa sarili mo. Pero kunwari, na-convict ka, tapos nag-undergo ka lang ng probation, so, ibig sabihin, hindi mo naranasan ng makulong sa loob. Therefore, yung confidence mo, ganun pa din. Hindi ka rin parang kapag nag-apply ka ng trabaho, hindi rin siya yung parang worried ka na baka anong sasabihin ng iba or anong i-judge nila sa'yo. So, it provides the rehabilitation and in the community and it restores his dignity. So, yun ang benefits niya sa offender. So, justifies the philosophy of men by life is sacred, all men deserves a second chance, and individuals can change. Okay? Okay, these are the forerunners of probations. So, number 1, kapag nasa probation na sila, naalala niyo yung release on recognizance? What does it mean? Again, what does it mean when we say release on recognizance?
Bail bond.
Bail bond upon what? Paano yung release on recognizance? Diba we have different types of bail and one of that is release on recognizance, which has been tackled last week also. What is release on recognizance? Commonly known as bail to. Ano to?
Wala kang babayaran dyan, ma'am. Magano dyan yung mga yung mga kumare kapitan yun. Yung mga pinagkakatiwalaan ng ano.
Okay, tama. Release on recognizance, hindi siya money bail. Ang release on recognizance, meron lang specific tao or specific individual which is responsible, okay, for taking care of you. Okay, so therefore, kapag meron kang ginawang masama or ginawang kasalanan in times na nasa labas ka or not being incarcerated, then responsible sila doon. So this allowed defendants who agreed to certain conditions of release to return to the community to await for trial. So after setting bail, judges sometimes fail to take further action. So similar to a modern day probation, 'di ba? Ano 'yon, ma'am, await trial? Hindi naman kasi, 'di ba alam naman natin na kapag dinampot pa lang ng pulis, alam niyo naman siguro yung criminal justice system. Anong tawag dun sa isang tao? What do you call a person when it comes to law enforcement?
Suspect.
Suspect pa lang. So, therefore, hindi pa po siya kriminal. So, habang nasa suspect siya and then nagkaroon ng prosecution, okay? So, habang magkakaroon ng trial, magkakaroon tayo ng tinatawag na bail. Pwedeng magpiyansa siya na habang nagkakaroon ng trial, nasa labas na lang siya ng kulungan. Okay? Yung piyansa niya is only a release on recognizance. Okay po? So, meron lang responsible na tao. For example, hindi ka nga makukulong. Yung parang, kasi diba, nasa detention na yan kapag, detention cell muna kapag habang nagkakaroon ng trial. Diba? Nakakulong siya. Detention cell. Hindi pa naman siya totally convicted. Nasa detention cell muna. Pero yon, pwede rin siyang mag-await na lang ng trial sa labas by the release on recognizance habang nagkakaroon ng trial. So, similar to modern day probations, defendants were released to the community conditionally. If they failed to meet the condition of release, they were faced with the threat of revocation or parang dahil nasira nila yung tiwala or nasira nila yung conditions na yon. Therefore, babawiin nila yon and magsaserve sila sa loob ng kulungan. So, next, judicial reprieve. Again, what is reprieve muna? What is reprieve as you all know?
Delay. Suspend.
Delay, suspend, ibig sabihin, kanwari death penalty, hindi mo na itutuloy. So, judicial reprieve, it means empower judges to temporarily suspend either the imposition or execution of a sentence in order to permit a defendant to appeal to the Crown for a pardon. So, sentences were suspended seemingly to give defendants another chance. So, this documentation of practice in Boston dates back to 1830. So, ang judicial reprieve is, ito yung kapangyarihan or nagbibigay sila ng authority to judge to suspend their imposition of the execution. Pag nagkaroon ng judicial reprieve, therefore, si judge mismo ang merong power to suspend. Okay po? To suspend a certain conviction. Okay po? Or imposition of execution of their final sentence. Okay po? So, parang binibigyan sila ng time para makapag-apply doon sa ating probation. Yun ang judicial reprieve. History of probation. Saan ba talaga nag-start yan? So, nag-start yan sa England. Okay? England, it is where probation started in a form of suspending judgment and releasing offender on his own recognizance with the promise not to commit any more crimes. So, sa England, Nag-start yan. Ito si Matthew Davenport Hill. Okay, on August 6, 1792 in Birmingham, Warwickshire, England. He died on June 7, 1872. So, he is a British lawyer and penologist, many of whose suggested reforms in the treatment of criminals were enacted into the law on England. Okay po? So, nag-start yan, ang ating probation, nag-start yan sa England. Ang nangyayari, yun nga, nagsususpend muna sila ng judgment. Ang tawag doon ay judicial reprieve. In exchange of releasing the offender, sabi nga natin, in tinatawag nating release on recognizance. In a promise na alam not to commit any more crimes. So, si Hill or si Matthew, okay, Hill had witnessed the sentencing of youthful offenders to 1-day terms on the condition that they be returned to a parent or guardian who would closely supervise them. So, nakita niya yon. When Hill became the recorder of Birmingham, he used a similar practice to offenders who demonstrated a promise for rehabilitation. So, inano niya rin niya. So, kung yung kanwari sa youthful, di ba? Alam naman natin kapag youth, automatically they are granted with probation. So, dahil ganun, in-apply din niya doon sa mga adult offenders. So, he used a similar practice to offenders who demonstrated a promise for rehabilitation and they were placed in the hands of a generous guardians who willingly took charge of them. So, for example, si Chucky, gumawa ng crime. Tapos, diba, nasa korte na sila, nagkakaroon ng trial. Ang mangyayari kay Chucky doon, no, mag-a-apply muna tayo ng judicial reprieve. Ibig sabihin, si korte parang isususpend mo niya yung final execution sa kanya. Therefore, marirelease si Chucky within the community with the help of yung tinatawag nating release on recognizance. So, for example, si Bernard David ang pinakakapitan. So, mangyayari nun, si kapitan ang may responsible kay Chucky Almerado. So, anytime na ano man ang gagawin niya, kailangan lang i-promise ni Chucky na hindi siya gagawa ng anumang krimen. No, Chucky? Nandyan ka pa ba? How about Bermar?
Ma'am.
Chucky, nandyan? Okay.
Nakikinig po.
Okay, nakikinig pero nakahiga, no? So, he practiced the method. So, ang nangyari, Hill had police officers pay periodic visits to these guardians in an effort to track the offender's progress and keep a running account. So, ang nangyayari po, si Hill, okay, gumamit siya ng kanyang mga police officer. And then, ang ginagawa ng mga police officers na to is pinupuntahan yung mga guardians. So, kung kanwari, itong police officer na to, ang guardian ni Chucky, sino? Si Bermar. So, tine-check nila yung progress na ginagawa ni Chucky. Okay. So, he practiced methods which include suspending judgment and releasing convicts in his own recognizance with the pledge not to commit any crime. So, again, Matthew Davenport Hill was the father of the England probation. So, for working as guardians of parents and employers of juvenile and the first-time offenders to save them from the stigma of prison life. Again, ang probation is applicable lang siya noon sa ating juvenile and dun sa tinatawag nating first-time offender. Kasi nga, di ba, kung i-release natin in recognizance, therefore, in exchange of a promise that they will not commit any more crimes, kapag nag-commit sila again ng crime, therefore, hindi na sila pwedeng tawagin as first-time offenders. That is called recidivism na or nagiging recidivist na sila. Okay po. Next, John Augustus. Sino naman si John Augustus? John Augustus is a Boston shoemaker. He is the father of probation in the United States. Yung kanina, si Matthew Davenport Hill is a father of probation in England. Si John Augustus naman is a Boston shoemaker, a father of probation in the United States. So, he began the practice of bailing offenders out of the court and assuming responsibility for them in the community. So, he was called the first probationer. So, the first probationer in 1841, John Augustus attended to a police court to bail out a common drunkard. Ang ginawa ni John Augustus, okay, pumunta siya sa isang police court para i-bail out yung common drunkard. Ang tawag doon is release on recognizance. Who became the first probationer? Hindi siya yung first probationer ha, kasi hindi po siya yung nag-apply sa probation. Yung binail out niya, which is yung tinatawag nating common drunkard. So, the offender was ordered to appear in court 3 weeks later for sentencing. So, nangyari, after 3 weeks, tinawag din yung for sentencing. The drunkard who was considered as the first probationer returned to the court as a Assabar man, accompanied by Augustus. To the astonishment of all in attendance, his appearance and demeanor had dramatically changed. So, bailing hundreds of offenders between the years of 1841 and 1859, John Augustus is most often credited as being the founder of probation in the United States. So, he considered the person's character, age, and factors that would impact the offenders after release. In dubious cases, he required the offender to attend school or to be employed. So, Augustus Activities provided the origins for the present tense investigation as well as common conditions of the present day community supervision such as education and employment. So, ganito. So, ang ginawa kasi ni John Augustus, he is a shoemaker. Boston shoemaker. Ang nangyari, okay po, so, nag-start muna siya dun sa mga common drunkards. Yung mga, alam yung mga lasinggero. So, doon is, sa England, ay sa US, okay, what I mean sa US, kinukulong nila mga common drunkard na yan. So, ang ginawa ni John Augustus for the year, sabi niya, between the years of 1841 to 1829, lahat ng nakikita niya na parang nagiging lasing lang dahil sa ganito, pero mabait naman. Diba, may mga lasinggero, pero alam naman natin na mabait sila. Ito talaga yung ugali nila, hindi sila nagko-commit ng crime. So, ang ginawa niya, nag-a-apply siya lahat na release on recognizance. So, ang ginagawa niya, bine-bail out niya yung mga nahuhuling yon, yung mga common drunkard na yon. Tapos, okay, ang ginagawa niya, bago niya piliin, hindi naman lahat ng lasinggero ay bine-bail out niya po, sa US. Ang ginawa lang niya, pinipili niya by person's character, age, and factors, sabi niya, that would affect or that would impact the offender after release. So, therefore, kailangan muna na gawin ni John Augustus is, tingnan niya muna yung character, if karapat-dapat ba siya to release out or to bail on release on recognizance. Kasi kung hindi niya makokontrol yun, therefore, sinong mananagot? Siya, di ba? Siya ang mananagot kasi naka-release on recognition siya in his name. So, ganon. So, nire-require niya yung mga release on recognizance niya to attend in school or sometimes to be employed. Kaya ngayon, yung kanyang visionary na ganon or yung practice ni John Augustus na choosing muna, hindi lahat ng common drunkard is rinirelease niya at saka yung ini-employ niya na kailangan nasa education sila or nagtatrabaho sila. Therefore, yun ang ginamit natin or inadapt natin as sa ating mga probation system. So, rehabilitation. So, in 1859, the first probation statute enacted in the Massachusetts shortly after Augustus' death. So, ang nangyari nun, nung namatay na si Augustus, doon nakita yung ginawa niya doon sa mga common drunkard. So, therefore, nagkaroon na ng first probation statute. So, the first juvenile court was established in Cook County in Chicago, Illinois, in 1899. So, Edward N. Savage. Okay, si Edward N. Savage is the ex-chief of police in Boston who became the first probation officer employed by the U.S. government. So, nung nagkaroon na ng first probation statute or parang law about the probation system, ang nangyari, ang kauna-unahang first probation officer is si Edward N. Savage. So, rehabilitation, it is the guiding of philosophy of probation. Sabi ni John Augustus, it became pretty generally known that my labors were upon the ground of reform. Sabi niya, that I confined my efforts mainly to those who were indicted for their first offense and whose hearts were not fully depraved, but gave promise of better things. So, parang, he always gives second chance. Diba? Sabi nga niya, it generally known that my labors were opened upon the ground of reform. Okay po? So, do you have any questions about the Forerunners concepts of probations? Do you have any questions? If you don't have any question, let's go with the next topic. Ayan. So again, this is the course unit 5, probation in the Philippines. So natapos na tayo sa history ng probation sa ibang bansa, saan siya nag-start, at sino yung mga forerunners niya. How about sa Philippines naman? So historical background, okay? We have the Commonwealth Act number 4221 known as the Philippine Probation Act, which was approved August 7, 1935. So it introduced in the Philippines during the American colonial period. So this law created a probation office under the DOJ. So noon meron na tayong probation under ng DOJ. So this act was short-lived due to grounds of unconstitutionality because of some defects in law's procedural framework. Itong Commonwealth Act number 4221 is parang hindi rin siya nagtagal kasi nakita na yung outcome na parang unconstitutional siya. So then next we also have Teodoro C. Natividad. Teodoro C. Natividad was considered as the father of probation in the Philippines. Okay po? So together with Ramon Bagatsing, they introduced the House Bill number 393. So which would establish a probation law in the country. However, it was pending in the Senate when martial law was declared. Kasi panahon to ni Marcos. Okay po? So si Teodoro Natividad, together with Ramon Bagatsing, nagpasa siya ng batas, which is yun yung probation law in the country. Kaso nga lang naging pending siya dahil nagkaroon ng martial law nun sa Pinas. So PD 968, also known as the Probation Law of 1976. So it was signed into the law July 24, 1976 by the late President Marcos. As amended, this law provides for the rules and regulations on probations which are currently enforced. So yan, hanggang ngayon po, ang sinusundan natin probation law in the Philippines is the PD 968. Pero, syempre, nagkaroon na rin yan ng mga amendments. And previously or recently, ang latest amendment ng PD 968 is yung tinatawag nating RA 10707 or RA 10707 po. Okay po? So, wala siya dyan kasi alam nyo, meron tayong, which is after ng prelims, itatakal natin yung PD 968 together with the amendments of RA 10707. So, the operation of probation system in 1976 to 1977 was a massive undertaking during which all involved the nationwide were trained in probation methods and procedures. So, anong nangyari? Siyempre, nagkaroon tayo ng batas about the probation. Nagkaroon na ng training yan sa iba't different parts of the Philippines. So, 15 selected probation officers were sent to USA. So, yung mga kauna-unahang probation officer, pinadala pa sa US yan para mag-training for orientation and training in probation administration. So, upon their return, they were assigned to train the newly recruited probation officers. So, after nilang mag-training sa US, yung mga newly recruited probation officers, training din nila kung anong tinuro sa kanila sa US. Then, nagkaroon tayo ng PD 1257. It was signed on December 1, 1977, amended the PD 968. So, Section 4, ano yung inamend niya? So, it provides the period during which an applicant may be granted. So, kailangan daw, it should be after the trial court shall have convicted a sentence, a defendant, but before he begins his sentence. Kasi dati, okay, pag doon sa PD 968, sinasabi lang niya, okay, makakapag-apply ka, okay, makakapag-apply ka ng ating probation kahit na nagkakaroon pa lang ng trial. Okay? Sinasabi ng PD 968. Kailangan, dati, sa PD 968, the law says that you can apply for probation even nagkakaroon pa ng trial. Therefore, wala pa tayong final judgment. Ngayon, sinabi ni PD 1257, binalitan niya yon. Kailangan, okay, mag-apply tayo sa probation kapag meron ng conviction. Kasi anong minimize nila doon? Yung gastos eh. Diba? Bakit po? Kung kanwari, trial pa lang, tapos nag-a-apply na siya. What if dun sa trial, lumabas, hindi naman siya convicted? Diba? So, parang sayang lang yung effort. So, ginawa ni PD 1257, kailangan mag-a-apply ka pa lang kapag meron ng final judgment. So, after ng final judgment, di ba, hindi ka naman agad-agad makukulong. Kailangan mo munang hintayin yung 15 days perfecting an appeal. binigyan ka nila ng 15 days allowance to appeal on the decision given by the judge. Nakakasunod po ba kayo? Nakakasunod kayo? Hello?
Yes po.
Opo, ma'am.
Okay. Sige. Sige nga, paki-explain nga ano sinasabi ko ngayon. Oh, walang maka-explain. Diba? Okay, balik lang tayo. Balik tayo dun. Meron na kayong procedure, ano ngayon? Criminal, CLG3, yung procedures? Wala pa. So, ganito, diba? Balik lang tayo sa process ng CJS. Okay, process ng CJS to, part ng court. Diba ang nangyayari, after nakuha ni law enforcement, dadaan ng prosecution. Si prosecution, siya yung magpa-file sa court. Ibig sabihin ba convicted na yung tao na yon? Hindi pa. He was suspect and then respondent kapag nakay prosecution na. Kapag nakay court na, ang tawag sa kanya ay accused. So therefore, accused muna siya, hindi pa siya convicted, hindi pa siya criminal. Therefore, nagkakaroon muna ng trial. So ang court, ang responsibility niya is to give judgment whether that accused is convicted of criminal or parang guilty siya or not guilty siya dun sa crime na sinasampa sa kanya. So, ang mangyayari, okay, sinabi kasi natin ng ating PD 968 na sabi niya, kailangan, sabi niya, pag nag-a-apply tayo sa court, ay nag-a-apply tayo ng probation, kahit nagtatrial pa lang, kahit wala pang final conviction na you are guilty, pwede ka nang mag-apply kay probation. So, in-amend yun ni 1257. Sabi niya, hindi ka pwedeng mag-apply doon. Kailangan, pwede ka palang mag-apply ng probation kapag meron ng final judgment that you are convicted or guilty of a crime. Naintindihan po ba? So, kailan yon, ma'am? Diba? Balik tayo ulit sa process. Kapag si court, okay, kapag si court nagbigay na ng conviction kay accused, diba hindi naman agad-agad ikukulong siya? Binibigyan siya ng 15 days period for the finality of the judgment. For example, si Mark Anthony Macam, okay, you are guilty beyond reasonable doubt. Final na po ba yung decision na yon? Magiging final na lang pa lang yung decision na yon if hindi siya nag-appeal within that 15 days. Di ba meron munang 15 days period for the finality of the judgment of the court or the judge. So, yung 15 days na yon na allowance period wherein pwede kang mag-appeal, di ba? Pwede mong pwede kang mag-ask ng tawag dito, revocation of judgment kasi may nakita kang ganyan. Ito yun yung 15 days. So, yung within 15 days na yon, sinasabi ni PD 1257, dun ka pa lang dapat pwedeng mag-apply ng probation. Nagigess niyo po ba niyan? Nakakasunod kayo? Nakakasunod?
Matudlo!
Nakasunod. Hello?
Opo.
Sige, mama.
Opo, ma'am.
Sige. Kung
Yes, ma'am.
hindi kayo nakakasunod, ewan ko, bahala na lang kayo sa exam nyo sa prelims, di ba? So, dahil ang exam nyo sa prelims, kahit 30 points yan, pinagawa sa amin is situational. Kaya nga binibigyan ko na kayo ng mga gantong examples. Wala kayong makikita ng mga kung ano yung nakasulat sa PowerPoint. So, it is a given concept, it is a given ideas and implied ideas. Okay po? So,
Edi 30 questions yung exam prelims, ma'am?
60.
30? 60 questions?
60 questions, 30-30. 2 sets. Okay? Then, each
Okay.
set, you only have 25 minutes for the 30 items. Okay, next, we have PD 1990. Okay, signed on October 5, 1985, which also amended some sections in PD 968. So, Section 4 was again amended by this law. Ano naman nangyari? After the trial court shall have convicted and sentenced a defendant within the period of perfecting an appeal, yung sinasabi ko 15 days period of the finality of judgment, suspend the execution of the sentence and place the defendant on probation for such period and upon such terms and conditions as it may deem best. So, provided that no application for probation shall be entertained or granted if the defendant has perfected the appeal from the judgment of conviction. So, ang ginagawa naman dito, kapag daw nag-appeal ka, okay? Kapag ang ating, okay? For example, si Makam niya. 'Di ba kapag yung 15 days period natin na yan, diyan natin malalaman if mag-a-appeal ka or hindi. Kapag daw nag-appeal ka sa korte na gusto mo mag-ask ng another trial, therefore, hindi ka pwedeng mag-apply ng probation. Sabi nga, no application for probation shall be entertained or granted if the defendant has perfected the appeal from the judgment of conviction. Nakakasunod po. Isa pa ha. Hindi nyo, okay, intindihin nyo muna. Okay, again. Kapag nasa korte na tayo, di ba? Kapag sinabi nga ni judge na you are guilty beyond reasonable doubt, hindi pa final yon. Okay? Kailan magiging final ang judgment na yon? Kapag
After 15 days.
Di ba? After 15 days na yon. So, yung 15 days na yon, meron kang time para mag-appeal. Okay? Para mag-appeal or mag-apply sa probation. Okay? Yung PD 1990 was responsible for asking, 'di ba? Or sabi niya, kapag daw nag-apply ka, kailangan kung mag-a-apply ka ng do sa 15 days na yun, kung mag-a-appeal ka, mag-a-ask ka na hindi mo tanggap yung decision ni judge, therefore hindi ka na automatically hindi ka na pwedeng mag-apply kay probation. Yun ang sinasabi ni PD 1990. 'Di ba? You have options. You have options. Again, 'di ba? Sa ating probation po, meron kang tawag dito, kailangan mo munang mag-apply, hindi yan automatically granted sa'yo. Una, balik tayo sa PD 968. Dati, sinasabi sa PD 968 na pwede kang mag-apply kahit nagkakaroon pa lang ng trial, kahit wala pang final conviction itong si judge. Diba? Or kahit wala pang finality of the judgment itong si judge. Tapos, binago yun ni PD 1257. Sinabi niya, kailangan makakapag-apply ka pa lang ng probation kapag perfecting in appeal na. Nag-gets mo na? Sinabi ni PD 1257 na mag-a-apply ka pa lang ng probation kapag PD 1257 na kapag perfecting in appeal na. Kapag meron nang sinabi si judge na final conviction and you're just waiting for yung 15 days perfecting in appeal. Naintindihan nyo na yan. Tapos sinabi naman ni PD 1990, inamin niya ulit yung 968, sabi niya, oo, sige, pwede ka nang mag-apply kapag during perfecting an appeal. Pero, sabi niya, okay, kapag nag-apply ka ng probation, therefore, hindi ka na pwedeng mag-appeal. Okay po? Sinabi din niya, kung mag-a-appeal ka, bawal ka nang mag-apply ng probation. Kasi ang nangyari no sa PD 1257, kasi sabay, no, ang ginawa nila, nag-apply na sila sa appeal, nag-apply pa sila sa probation. So, parang dalawa. Diba? So, kung mag-a-appeal ka, pwede ka pang mag-probation. So, yun ang inano niya. Yun ang ginawa ni PD 1990. Nag-gets nyo na ba yan? Ha? Nag-gets na?
Yes po.
Yes,
Okay. Kailangan nyo kasi maintindihan yan kasi ang gumawa ng exam ng CA nyo si Ma'am Mick. Baka alam ko naman gumagawa ng exam si Ma'am Mick. Puro situational din. Okay? We have the new administrative code. Okay? From November, lansang anong mic mo? Okay? Transfer the functions of supervising parole and pardon of offenders from trial courts to probation administration. So, nung nagkaroon naman ng new administrative code, yung ating, yung function ng nagsusupervise nating parole and pardon, nilipat na sa probation administration or sa PPA. So, the code was also changed that name of agency to parole and probation administration. Ito yung PPA. So, RA 9344, the Juvenile Justice and Welfare Act of 2006, provides probation as an alternative to imprisonment into juvenile offenders. Okay po. Again, so automatically, nag-grant tayo ng probation sa mga youthful offenders. Okay? Kaya ang probation sa juvenile is a right, not a privilege. Pero sa adult, it is just a privilege. So, nature and concept of probation. Actually, a suspension of sentence during the period of defendant is placed on probation upon application to the court by defendant. So, a mere privilege is granted rests solely upon the discretion of the court. Okay? So, sabi nga niya, merely an act of grace and clemency of immunity conferred by the state. Again, sino ang nagbibigay or nag-grant ng probation? Si government ba? Si president ba? Sino?
Si judge,
Judge.
po natin.
Judge po.
Okay. So, ina-apply kasi yan sa korte. Kapag nag-apply kayo ng probation, hindi po kung saan-saan sa korte yan. Therefore, si court din ang may kakayahan kung mag-granted ka ng probation or hindi. So, merely an act of grace and clemency or immunity conferred by the state. So, privilege. When we say privilege, it is a peculiar benefit or immunity conferred by law on a person or group of persons not enjoyed by others or by all. So, what is the objectives of a probation law? Number 1, to promote correction and rehabilitation of an offender by providing him with individualized treatment. Next is to provide an opportunity for the reformation of a penitent offender. Pag sinabing penitent, diba, nagsisising offender, diba, bibigyan daw siya ng reformation. Prevent the commission of offense, to decongest our jails and prisons, and to save the government much needed finance for maintaining convicts in jail. So what are the advantages in probation naman? It prevents crimes by offering freedom and aim only to those offenders who are not likely to assault a society again. Yun lang ang kanyang advantages. Kailangan ibinibigay lang niya doon sa mga offenders na yung quality nila is, or yung nakikita natin na hindi nila gagawin yung crime ulit. Di ba nga, in a promise na they will not commit any more crimes. So, protect society by placing under close supervision and non-dangerous offenders while undergoing treatment and rehabilitation in the community. It conforms to modern humanistic trends of penology. Kasi humanistic yan, mas makatao yung mga ating non-institutional correction, di ba? Which is the community-based. Paano hindi makatao? Kasama nga nila yung pamilya nila, di ba? So, next is prevents youthful of the first-time offenders from turning into hardened criminals. So, yung mga, again, ang probation, allowable lang siya dun sa mga first-time offenders. Okay po? And youthful, sabi niya, in turning into hardened criminals. And a measure of cutting enormous expense in maintaining jail. So, again, kapag nag-undergo sila ng probation, less na sila dun sa gastusin na papakainin pa sila, bubuhayin pa sila ng gobyerno. So, another, it reduces recidivism and overcrowding of jails and prison. Recidivism, again, it is the paulit-ulit na ginagawang crime. Reduces the burden on the police force and institutions of feeding and guarding detainees. Give the first and light offenders a second chance in life and provides for reformation. So again, pang first-time offenders lang siya. It restores to successful probationers their civilized laws view of the offense, advocated by the United Nations in its various congresses in crime prevention and treatment of offenders. Okay, these are the 4 elements of probation. We have the PSIR na sinasabi niya, or the Post-Sentence Investigation Report. Again, PSIR, Post-Sentence Investigation Report, which will serve as the informational basis for the court's decision to grant or deny probation. I-discuss ko din yan kung paano mag-apply sa probation doon sa ating first week ng midterms. Kasi ang nangyayari, kapag nag-apply ka ng probation, di ba? Mag-apply ka sa court. Tapos, ang gagawin mo nun is, ang gagawin ni court nun is parang ide-direct ka niya sa isang probation, parole and probation administration, o tinatawag natin PPA. Ngayon, yung PPA na yon, meron siyang i-assign. Meron siyang i-assign na probation officer, okay, parole and probation officer, para mag-conduct ng post-sentence investigation report. So, post-sentence investigation report is a 60 days report na kailangan gawin ng probation officer. Ano pong gagawin ni probation officer nun? Ang gagawin niya is i-check niya kung qualified ka ba na tanggapin as probationer or pwede ka bang grant ng probationer. So, i-investigate lang niya. Titingnan niya kung ano yung buhay mo, saan ka nakatira, ano ba yung crime na ginawa mo, ano ba yung behavior mo. So, yun yung mga probation officer natin. And then, ang mangyayari nun, yung PSIR niya na yun, within 60 days, ipapasa niya yan kay court. So, therefore, yung korte, yung based on that report, doon niya malalaman if qualified ka ba or hindi. Nakuha po. Diba? Sabi natin nga, si court or si judge ang nag-grant ng decision whether you are qualified to apply for probation or not. So, therefore, si judge po, okay? Si judge, nibibase niya yung decision niya doon sa post-sentence investigation report na ginawa ni probation officer. So, ito na yung laman ng buhay-buhay mo, yung mga behavior mo or what. Okay, next. We also have the conditional suspension, execution of sentence by the court. Okay. Also, we have the conditions of probation. It is the imposed by the court to protect the public safety and to foster the rehabilitations and reformation of the probationer. Ito yung mga conditions na iset sa'yo ng korte once na nag-grant sa'yo ang probation. And then, we have supervision, guidance, and assistance of the offender by a probation officer. The probation officer, after nag-grant sa'yo ni court na, okay, you are granted to undergo a probational system. So, therefore, mag-a-assign sila ng probation officer. Ang trabaho ni probation officer nun is to supervise, i-guide, and assist ka kung ano yung mga gagawin mo within the community. So, again, that is the 4 elements of probation: PSIR, conditional suspension, conditions of probation, and your supervision, guidance, and assistance by the probation officer. Okay, except where death penalty is imposed, a judgment of conviction in a criminal case becomes final when? Kailan ba? Kailan nga yung nagiging final ang judgment na ating criminal case? No appeal is seasonably perfected. Yun nga, within 15 days, walang nag-appeal. Therefore, final na. The accused commences to serve the sentence. So, the right to appeal is expressly waived in writing. The accused applies for probation, thereby waiving his right to appeal. Okay, ganito. Balik tayo dun sa discuss ko kanina. Diba, meron tayong, sabi ko nga, yung judgment na binigay ni court or binigay ni judge, meron muna yung 15 days bago magkaroon ng finality. Ngayon, ma'am, lagi po ba natin muna na hihintayin yung 15 days na yon before po na maging final ang judgment ni court? Okay, hindi po. Okay? Except death penalty. Ano, kapag death penalty yan, final na yan. Okay po? Final na yan. Pero dahil wala naman tayong death penalty, again, meron silang 15 days. So, for example, binigay ni Judge Salas na, okay, you are guilty beyond reasonable doubt. Meron kang 15 days niyan. Yung 15 days na yan, magiging final lang ang judgment ni judge. Kung, kanwari, natapos na yung 15 days. Or, kanwari ikaw, for example, si Makam, nag-apply siya ng appeal. Kapag nag-apply ka ng appeal, therefore, tinatanggap mo yung judgment ni judge na you are convicted. Kapag nag-appeal ka, therefore, magkakaroon again ng another trial. If naman, sinabi ni convicted, sige po, magsaserve na ako ng sentence ko, therefore, tinatanggap mo na alin? Na final na yung judgment ni judge. Also, if yung isang tao or yung isang offender, winif niya into writing na hindi na po ako mag-a-appeal. Okay, hindi na ako mag-a-appeal. Therefore, kahit wala pang 15 days, final na yung judgment ni judge. Another, when the accused applies for probation. Again, kapag nag-apply ka ng probation, therefore, tinatanggap mo na that you are guilty. Thereby, you are waiving your right to appeal for the judgment of the judge. Therefore, ayan na. Mag-a-apply ka na sa probation. Diba? Again, hindi ka naman makakapag-apply kay probation unless wala munang final conviction or finality of the judgment. Naiintindihan po ba? Naiintindihan? Nagagets nyo yan? Nakakasunod. Next. So, what are the penalty qualification for probation? Paano naman natin malalaman kung qualified ka mag-apply kay probation? Okay, number 1, the penalty must not exceed 6 years, equivalent to prison correctional imprisonment. So, other than that, kapag ang penalty na binigay sa ni judge is, kanari, you're guilty beyond reasonable doubt and you will serve at 12 years, 1 day to 20 years imprisonment, therefore, hindi ka pwedeng mag-apply ng probation. Yung mga pwede lang mag-apply ng probation kapag ang penalty na binigay sa kanila must not exceed 6 years. Next, in cases of multiple convictions, so the basis for determining whether or not the penalty qualifies, the convict for probation is the term for individual imprisonment. So, for example, tawag dito, madami kayo, group sentence yan, diba? Gumawa kayo ng crime, tatlo ang gumawa ng crime. So, hindi naman kapag po ba nag-apply yung isa ng probation, automatically yung dalawa ma-apply na. Hindi. O, kanwari, tatlo kayo, tapos yung isa gustong mag-apply, bawal siyang mag-apply, pwede po. Okay po? So, the basis for determining whether or not the penalty qualifies to convict for probation is the term of individual imprisonment and not the sum total of all prison term imposed in the decision. Next, fixing the cut-off a maximum term of 6 years imprisonment for probation is based on the assumption of what? Bakit ba laging meron siyang deadline na ma'am, 6 years lang dapat yung penalty? So, it is based on the assumption that those sentenced to higher penalties pose too great a risk to society. So, iniisip nila na kapag nag-apply ka kasi or kapag in-apply natin or inalaw natin na mag-apply yung mga merong 12 years pataas or 6 years pataas, therefore parang mas malaki na yung risk niya, di ba? Baka yung pinapakawalan natin sa community is a serial murderer pala. Ayan. So, who can apply for probation? Ayan. The probation law shall apply to all offenders. To all offenders, except those entitled to the benefits under the provisions of PD 603 or the other similar laws like RA 9344. Kasi ito, kapag PD 603 or RA 9344, automatic na yan, hindi na kailangan pang mag-apply ang isang bata. So, kung kanwari, offender ka, tapos nakita mo, qualified ka naman mag-apply sa probation na ang penalty mo is not exceeding for 6 years, therefore, you can apply. So, yun lang. Do you have any questions about the topic in First Unit 5? Ano yung gusto mong ipaliwanag? Ganyan? You can raise your questions now.
Ma'am, question po.
Yes?
What if po yung isang tao, yung convicted siya ng 3 crimes, kunyari, murder, arson, pati po yung robbery.
Yes.
Ano po yung mangyayari po nun?
Hindi siya pwedeng mag-apply ng probation. Kasi automatically yung mga crimes na yan, di ba, kabilang siya sa heinous crimes. So therefore, di ba, so therefore yung penalty nila is mag-i-exceed na ng 6 years. Again, tandaan nyo, ang pwede lang mag-apply sa probation kapag ang penalty binigay sa kanila ni judge hindi nag-i-exceed ng 6 years. Ma'am, saan sila pwedeng mag-apply? Pwede sa pardon, di ba? Pwede sa GCPA. So, madami namang ibang non-institutional correction. So, ang probation nag-a-apply lang siya dun sa mga penalty na 6 years lower po ang fine or penalty na binigay ni judge. Okay po?
Yun lang po, ma'am.
Okay. Do you have any questions pa?
Incorrigible no rete, reclusion perpetuaning sentence darete.
Oh, again. May tanong pa po ba?
Wala na po.
So, if wala nang tanong, then stop ko na tong recording.